That's OLTMANPATENT.com. Spokesperson, not an attorney.
Times are tough, and right now those in the commercial world know that being heard via advertisements is the name of the game. AmpSquare.tv understands how important advertisement is and is proud to express that it's truly the only plugged-in internet television production company on the market. Amp2.tv live streams all their shows across all the major selling markets in the U.S. and abroad. Call them at 866-224-5422. The AmpSquare.tv library allows productions to be seen over and over again, making commercial platforms more usable. Call 866-224-5422. Toll free 866-224-5422. Amp2.tv, the first and only internet television network that's truly plugged in. 866-224-5422. That's AMP2.TV. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we practice intellectual property law, including patents, trademarks, and copyrights. You can check us out online and view all episodes of this show on our website at oltmanpatent.com. That's OLTMANPATENT.com. A very special guest in studio this evening. His name is David Batchelder. David practices primarily in the area of Social Security disability, and that's what we're going to be discussing this evening after we discuss the recent news, the tragedy in Charleston, and some of the aftermath of what has occurred. So, David, thank you so much for joining us this evening.
Happy to be here.
So I'd like to start out, of course, this was a tragic event, a shooting in Charleston at the church, resulting in the deaths of 9 people. Fortunately, the perpetrator has been captured, and it's sparked a debate with respect to the Confederate flag at the state capitol. Now, David, you lived in Charleston for a period of time. What are your thoughts on this? It appears now that the governor, as well as presidential hopeful Lindsey Graham, may have sort of turned a new leaf on this and are now actually advocating removing the Confederate flag. And most people think that this is past due at this point.
Right. It's been a long time coming, hasn't it? I mean, with I think it's a weak argument that it's a symbol of their past. It's not a symbol that should be flying over a state capitol, in my opinion. I love Charleston. It was a great place to live. They're some of the nicest people that you ever want to meet, black, white, it didn't matter. You really do feel that Southern charm and Southern hospitality when you live in Charleston, when you visit Charleston. And it was just horrific. And to maintain that symbol of repression, the symbol of oppression, in their federal buildings, their state buildings, it just makes no sense. It's well past time for that flag to come down, I think.
And hopefully that'll happen. It appears that in South Carolina, they actually have to get a 2/3 majority vote, a supermajority, from both chambers in their legislature. But if anything's going to be the impetus for making that happen, it looks like it's going to be this tragedy.
Certainly.
The other thing that I found really amazing also is the judge's comments. They seem pretty out of place at the arraignment of the shooter, Dylan Roof, his name was.
Right.
In which the judge said that everyone has to find it in their hearts to have compassion for the shooter's family for what they're going through. That seems like that just was so out of place, considering that it was just 48 hours. Or even less than that after the shooting itself, and of course the shooter's families didn't have, the shooter's family members didn't have anyone gunned down in their
Right.
family like the victims did, and that might be a statement that might make sense many years from now. But this soon after the shooting, it seemed totally outrageous.
No, too early for that. Way too early for that.
Yeah, and sometimes judges, even though he's thinking that might make sense in his own mind, they're not used to being on camera under the eye of the national public, and that's something that he probably wasn't thinking about before he said it.
I think you're probably right.
He probably regrets doing that. But, this was just a terrible tragedy, but it is amazing to watch how, the communities come together and how the families of the victims have actually come out and said that they've forgiven the shooter.
Right.
It's really remarkable, something you rarely see in the wake of these mass shootings or these incidences of mass murder, especially here where, if anything, you would expect the anger to be even more enhanced because it's a hate crime. This isn't a random crime. This was a racially motivated hate crime. And even so, they've still found it that they could forgive the shooter under these circumstances.
Well, really not surprising considering the source, frankly. 9 people, Bible study on a Wednesday night at church. These are the people that you would expect to be Christian people extending their forgiveness to in the most outrageous, most horrific events that happened. And these are the people that we would expect to reach out and forgive, Christians.
Right. So we'll be following this story and seeing what happens. So moving on to the topic for tonight that we had originally planned on discussing.
Thank you.
Yes. You do practice disability law. That's primarily what you do. I was wondering if you could just give our listeners a brief introduction to what is Social Security disability and when somebody might seek counsel.
Sure. My practice concentrates solely in obtaining Social Security disability benefits for people under Title II or Title 16 of the Social Security Act. Title II, Social Security Disability Insurance Benefits, or SSDI benefits, and those are disability benefits based on what you've paid into the system. So just like any other long-term or short-term disability insurance benefit that you could purchase in the private sector, except it's through the federal government. Most people think that when they work, they pay into Social Security, they're paying in for their retirement benefits. But if you don't make it to age 65, 67, and you become disabled beforehand, disabled meaning the inability to engage in any substantial gainful activity or the inability to work due to a medical impairment that exists for 12 months or more. So you have worked, you've paid into the system, you have acquired sufficient quarters of coverage, meaning you've worked long enough and paid enough into the system to qualify for the Title II SSDI benefits, and you're disabled. And the other benefit, the other disability program that you can avail yourself of if you're disabled is SSI, or Supplemental Security Income Benefits under Title 16 of the Social Security Act. Same standard of disability, inability to engage in any substantial gainful activity due to a medical impairment, but this is a needs-based program. Has nothing to do with quarters of coverage or how much you've paid in. You don't have to pay anything in. But you have basically no money, and you are disabled. That's Title 16 SSI. And we represent people, both of these programs, from the initial application stage all the way to the 11th Circuit Court of Appeals if necessary.
Now, you mentioned SSI, or Supplemental Security Income. With that, you automatically, if you are eligible for $1 of SSI, you're automatically eligible to receive Medicaid benefits. Isn't that right?
That's correct. And with SSDI, you're entitled to Medicare benefits. The kicker to the Medicare with SSDI is that you have to be disabled for 29 months before you're eligible for the Medicare. So it's an archaic law written in way before time, but it still stands today. It should be changed. It doesn't make any sense for that waiting period to still exist, but you have to be disabled for 24 months plus the 5-month waiting period, so for a total of 29 months before you're eligible for the Medicare from the disability onset date.
So does that date, you said the disability onset date, how is that determined? Is that the date that you apply for benefits, or is that some date that's determined to be in the past?
It's a date typically when you last worked. You can't work and pursue Social Security disability benefits at the same time. Like you can't perform substantial gainful activity, more specifically. But usually what happens, your disability onset date is typically when you last work. So many times it is also the date that you apply for benefits, but it could be a different date. It's typically when you last worked, or when you're diagnosed with an illness and then you stop working. That's your disability onset date.
I guess that could probably be tricky if you, let's say, lost your job or were laid off, and then at some point after you're laid off, then you apply for Social Security disability.
Right. It gets tricky because the judges are going to want to ferret that out, because that'll be one of the first questions at the hearing. When did you last work, and why did you stop working? And there are a number of different forms that will be in the file that will show when they last worked and why they stopped working, and we'll make sure that they understand that the disability onset date is directly related to the medical impairment that stopped them from working. All this has to be backed up with the medical evidence.
Now, one of the things that, one of the misconceptions perhaps a lot of people have is that they only can go to a disability lawyer after they have applied for Social Security disability benefits and have been denied, and then they hire an attorney to appeal it.
Right.
However, you actually recommend often that people actually see an attorney first before they've initially applied for benefits.
Absolutely. I think it's crucial to set the tone early and often. I want to set the theme for why the claimant is disabled. I don't want to trust the Social Security representative looking at my client through a window that's going to spend 15, 20, maybe 45 minutes working on this application with my client. I don't want to trust that person who's not the person that typically denies my client. But I'm not going to trust that local office representative to get all the facts in that I want to establish my case. I want every element of my case in that initial application, and that's why we'll spend 3-4 hours on the initial application, filing it online to make sure it's that complete.
And often that's because the person working at the Social Security office might not be asking the right questions that you would know to ask, because you're trying to make it very clear on the application so that anybody reading it can understand that this person can't work, that they have an inability to function with respect to substantial gainful activity, and there might be details that you can draw out of that person that somebody that's spending 30 minutes with them at the Social Security office is not going to be able to.
That's exactly correct. And I can't tell you how many times I've sat in front of a judge and they will look at the file and they'll say, well, you're alleging that they have this, and this impairment, but I don't see any of that in the initial application. So when the claimant filed the initial application, they said they had a back injury and their right leg hurt, but now you're telling me it's something to do with the knee and the ankle and the neck, and why wasn't that in the initial application? Well, obviously I wasn't representing them during the initial application stage. That's why it's not there. But once we got involved through the appeals process, we made sure that every impairment, every condition, every medical impairment that could possibly affect your ability to function effectively in the workplace is going to be included in that appeal paperwork, just like it would have been included in the initial application if you would have hired me then.
And I've worked on, not on Social Security disability so much, but I've worked on the total and permanent disability discharge process for student loans, which is actually a slightly different but similar process, where if the Department of Education determines that you are disabled permanently, then you can have your federal student loans discharged. And there's a form that you fill out, but if you're filling it out right, where it asks you to list all of your impairment, you just write 2 words, "see attached," and then you have a much lengthier typed answer as opposed to a handwritten answer that
Right.
you put on the form itself. And I'm sure that you have a similar protocol where you make it as detailed as possible, describing every impairment. And often with clients, I'm sure, as you've seen with disability, they might not freely share that with somebody at a disability office.
Absolutely correct. I had a perfect example this morning with a client I had before a judge who wanted to, it was a crucial issue, whether it was an 11th grade education or a 6th grade education. And I started this area of law, I learned everything I know about Social Security disability when I lived in the Appalachians for 4.5 years. I lived in East Tennessee, Southwest Virginia, North Carolina, and represented people in the coal fields. And you would be amazed at how many people in this country still can't read or write. And there's a specific listing, there's a specific impairment, a specific disability. If you have an IQ score of 70 or below and some other severe impairment, under Section 1205C of the listings, you are considered disabled. Now, this has to be a lifelong impairment, so you show it by way of school records and whatnot, and hopefully there was psychological testing done in the past that shows IQ scores 70 or below. But people don't want to talk about that. People are not going to just volunteer that they can't read or write. They've been covering it up for years and years. Why would they just volunteer this information now? They don't understand how crucial it is to win their case, to convince a judge that, no, really, this person can't read or write. So it's true. A lot of times it's like pulling teeth to get it out, but frankly, if you're doing your job, if you're doing your job well, you should be able to figure out every problem that this person has that would affect their ability to function in the workplace.
And with respect to the appeals process, how does it work if you submit an application and it's denied? What happens from there, and what is your role?
Okay, every appeal is 60 days, so you always have to consider 60 days, 60 days, 60 days. That's every appeal in Social Security disability is 60 days, plus 5 days for mailing. Your case, the initial application goes to the state agency, the Office of Disability Determinations. It's denied. 67% of all cases are denied. You then will appeal, file a request for reconsideration. That means the case goes back to the same state agency that denied you before, and you ask them to reconsider their initial denial. It's assigned to a new medical adjudicator, but 88% of all those cases get denied again. You then have 60 days to file a request for hearing to get your case in front of an administrative law judge. Broward and Dade, where I practice primarily, 22 months to get a hearing in Miami, 21 months to get a hearing in Fort Lauderdale right now.
Now, does your benefits accrue from the date of your application?
Yes.
So from the date of your application, if eventually your appeal is successful, even though you've been denied, you would get a lump sum payment for all of those months leading up to when you were finally approved.
That's correct. The initial application typically runs about 4 months. Request for reconsideration usually runs about 2 to 3 months, and then you wait about 2 years to get a hearing in front of a judge.
Now, when you say judge, these are not actually people that are part of the judiciary. They're not part of the court system. They're actually part of the executive branch of government. Are they any? How do they compare to judges that you might see in state or federal court?
Well, you're correct. They're administrative law judges, and they're not employees of the Social Security Administration. They're independent. How do they compare? I guess they compare just like any other state or federal court judge. They range from well, some know the law very well and will apply the law and consider the facts and act like judges. Some judges will come with an agenda and deny most cases. There are very few judges that will award most cases, but I think it's similar to a lot of judges out there. There are some good, some bad. The ones that I'm looking for are the ones that are in the middle. I don't need a judge that's going to pay every case. Frankly, they are very few and far between now. When I first started practicing in this area of the law in 1992, there there are a few judges out there that were very liberal and were very kind, and they were very gracious in paying a lot of cases. There aren't many of those judges around at all anymore.
There was a recent story on 60 Minutes, I think last year, that had a lot of Social Security disability attorneys rolling their eyes, saying that there was this rampant disability fraud. When I saw it, and I wasn't really aware of the statistics, but it just sort of looked like, after the 2000 election, when there were these accusations of voter fraud, and then when statisticians looked into it, the incidence of voter fraud was just absolutely negligible. I'm guessing it's something similar here, that the idea that there's just this rampant fraud and that taxpayers are just getting taken for a ride by these freeloaders and all of this rhetoric, it's very unlikely to be true for the reasons that you just described.
It is not accurate at all. As from a practitioner's standpoint, I can tell you that since in the last 23 years, this has been the most difficult period that I've seen advocating on behalf of Social Security disability claimants. It's a very hostile agency. It can be, at times, a very hostile bench, and we are fighting harder now than ever on behalf of Social Security disability claimants. It's as bad as it's ever been, and really, of course, I'm advocating for you to hire an attorney, but if you think that you're going in front of an administrative law judge now, unrepresented, then it's just lambs to the lions, because they're not going to get a favorable determination without counsel zealously advocating on their behalf and making sure that they know all the ins and outs of the system to get them there.
Now, with respect to hiring an attorney, a lot of people, of course, are always worried maybe they can't afford an attorney. But on a lot of especially on the appellate process, you actually can get awarded a contingent fee out of the that are attached to the benefits if it's successful.
Right.
So the client doesn't actually have to pay a retainer or anything like that in order to retain you in most instances.
Right. Most instances, meaning through the appeals process, if our fees are regulated by federal statute, we're allowed to charge 25% of the retroactive benefits, 25% of the back pay, or $6,000, whichever is the lesser amount, through the administrative law judge hearing level that we were talking about. So if I win the case in front of the judge, the fee is 25% or $6,000, whichever is the lesser amount. So they cap the fee at $6,000. If we're denied by the judge for whatever reason and we have to go to the appeals council or federal court, then the fee is a flat 25% just because of all the extra work that's involved.
And of course, having to pay that fee out of the retroactive benefits is far better than getting denied altogether, in which case you get no benefits at all. So.
Exactly, and no benefits, no fee. So and really, we are very selective about our clientele. If we're agreeing to represent you, you know that you have a viable disability claim. We vet our clients relentlessly at the outset. We spend a lot of time with them at the outset, knowing most likely we're going to be together for the next 3+ years. So if I'm taking your case, you know that you have a good, strong case, and I'm not going to waste your time. I don't have the time to waste on frivolous border cases. We have to win every case that we take in front of the judge. If we don't win, 25% of nothing is nothing, and I have a small shop. I have to have every case win.
Now, one of the interesting things that I think would be very aggravating to Social Security disability applicants is when they get a denial and all it says is, yes, you cannot engage in whatever occupation you were previously engaged in. However, we find that you can still do some work, but it doesn't say what work you can do. Can you, on appeal, ask them and say, please specify what work can this person do with whatever disability they have?
It's a cookie-cutter form letter. You're dealing with an apathetic government bureaucracy. They're going to try and fit as much as they can into form letter 1, 2, 3, 4. Sometimes they'll even say you can go back to work as a cashier, like you described it before. These letters are very offensive to people, and obviously very offensive to my clients. But that's why I'm on the phone with them the day the letter comes out to explain to them, look, I know you can't do it. They know you can't do it, and that's why we appeal it, because it doesn't make any sense. But it's a slap in the face when you've worked 35 years as a construction worker, and then you blew your back out and you can't do anything anymore, and then they tell you can go back to work mixing concrete.
It's very disheartening. We have just a minute left. This has been a fascinating conversation. David, if you could give out your contact information to our listeners.
Sure. My name is David Batchelder. The telephone number is 305-371-8127. You can check out our website at www.disabledworkersbenefits.com. And our office is located in North Miami, and we handle cases all over South Florida.
I'd like to give a very special thanks to my guest, David Batchelder. Please tune in next week, Tuesday night from 6 to 6:30, where my guest will be DUI defense lawyer Warren Redlick, discussing his infamous DUI flyer that you may have seen on the news. This is Jeff Van Treese for Talk Legal. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program